many possible explanations have been put forward as a justification for the doctrine of frustration as a part of the law relating to discharge of contracts. Two theories are most well known. The first theory is theory of implied term. The theory of implied term was explained by Lord Loreburn in F.A. Tamplin Steamship Company Limited versus Anglo-Mexican Petroleum Products Company Limited. His lordship emphasized that the courts do not have the power to dissolve a contract, but they can examine the circumstances of the contract to see whether the parties contracted on the footing that a state of things would continue to exist. If so, a term to that effect would be implied. If that term fails, the contract should be over. This theory has been criticized. It has been suggested that the doctrine of frustration is really a device by which the rules as to absolute contracts are reconciled with the special exceptions which justice demands. It has been said, in ascertaining the meaning of the contract and its application to actual occurrences, the court has to decide not what the parties actually intended, but what, as reasonable men, they should have intended. The court personifies for this purpose the reasonable man. The second theory is the just and reasonable solution theory. In a subsequent case, British Movie to News Limited versus London and District Cinemas Limited, Lord Denning attempted to explain the doctrine of frustration on a different basis. He said, I quote, "The court really exercises a qualifying power, a power to qualify the absolute, literal or wide terms of the contract in order to do what is just and reasonable in the new situation." Unquote. But this statement was not approved when the case went before the House of Lords. The observation of Lord Loreburn that no court has an absolving power was re-emphasized. Referring to the theories, Justice B.K. Mukherjee of the Supreme Court of India said in the Satyabrata case, I quote, "These differences in the way of formulating legal theories really do not concern us so long as we have the statutory provision in the Indian Contract Act. In deciding cases in India, the only doctrine that we have to go by is that of supervening impossibility or illegality as laid down in Section 56 of the Contract Act, taking the word impossible in its practical and not literal sense. It must be borne in mind, however, that Section 56 lays down a rule of positive law and does not leave the matter to be determined according to the intention of the parties." Unquote.